Well, good morning and welcome to today's session on this beautiful day in sunny Adelaide. The topic of this morning's talk is how to correctly handle misconduct. I just wanted to start with some comments and observations about my talk today, just so the context is understood. My talk will be provided from the perspective of the lawyer, and because of what we're talking about today, there will be a focus on the federal workplace laws, which of course govern the private sector in South Australia. And my talk will discuss the clear interaction between any adverse or disciplinary action that might be taking, including dismissal, in the context of the common employment applications that might be brought in response to that, in particular, the dismissal application. I'm happy to take questions during my talk or at the end. In terms of the topics of today's talk, I'll be talking about what disciplinary options are available in relation to poor performance and misconduct, reasons for dismissal, further detail in relation to performance and conduct, and then a discussion in relation to recent decision developments that we can glean from those. In terms of the disciplinary options, I thought I'd just start by explaining the difference between poor performance and misconduct, because it's still something that in our experience comes up from time to time. And indeed, I was having a discussion with one of my nephews last night who was talking about an instance in which he was dealing as president of a sporting club, where there was an interaction between one of the staff and a female colleague where there was some touching involved, and he asked me how many warnings you had to give in that situation. And I explained to him the difference between poor performance and misconduct. So in terms of poor performance, it doesn't look at the behaviour of problems of behaviour addressed under the issue of misconduct. Poor performance looks at whether the job which the employee is being taken to has been done properly. And misconduct, on the other hand, or unacceptable behaviour occurs when policy is broken or some other unacceptable behaviour occurs at the workplace. In terms of the disciplinary options in response to either poor performance or misconduct, counselling, warning and suspension are all options. Suspension really is an option in the context of when you're looking at misconduct rather than poor performance. In terms of the reasons for dismissal, I'll be focusing on performance today. But in terms of the actual reasons for dismissal, there are four main reasons that can lead to dismissal. Conduct today, actually that is whether or not we actually do the job. Certainly in our experience, that's something we're seeing more and more today as we've got aging groups in Australia. And the last one, of course, is governance. That's about the requirements of the business and whether particular roles are required to be continued. In terms of performance and conduct, I thought I would start by setting the scene in terms of what are the actual risks that you face from a legal perspective. So what are the claims risks that you face when you're looking at issues such as performance and misconduct? Well, the purpose of performance management is not really just about the management of that risk. It's to help a business maximise its productivity by enabling employees to perform to their full potential. A secondary purpose might be that it's the integral part of a defence to any adverse action that might be taken against an employee who's not meeting the standards of the business. The most common type of employment that might be brought by an employee who has adverse action taken against them, whether that be because of poor performance or misconduct, is and remains an unfair dismissal applications. The numbers relating to such applications, though, are interesting 80% of unfair dismissal applications are settled at conciliation. A pretty high number. 88% of those applications that do not settle at conciliation are dismissed, either for a jurisdictional reason or at the conclusion of the trial stage of the process. 12% of applications are actually successful. In 9% of those, compensation is ordered as a remedy, and in only 1%, reinstatement is ordered, which, as we know, is the primary remedy for unfair dismissal applications. The numbers, frankly, are reasonably sobering for an employee seeking either reinstatement or significant compensation as a remedy in response to their dismissal. So in terms of the, when we're talking about the unfair dismissal jurisdiction, that's contained in the Fair Work legislation. The objects of it are to establish a framework for dealing with dismissals that balances the needs of business and employees. The procedures are intended to be quick, flexible and informal. And as I said, the objectives also include reinstatement primary remedy. An aim of these provisions is to achieve a fair go all round. To be able to seek to bring an unfair dismissal application, an employee must have been employed for a minimum employment period of 12 months for a small business and 6 months for all other businesses. There's no minimum employment service requirement for general protections applications, and we do see a lot of employees who are dismissed during the probationary period pursuing that particular option for that reason. Other exclusions apply, such as those employees whose employment has come to an end because of the completion of a fixed-term contract. Unfair dismissal remedy is something that's been around for some time. It was formerly in the state jurisdiction. It's been in the federal workplace law since 1993. The Act identifies a list of considerations that the Commission is required to consider to determine whether a dismissal is unfair, unjust or unreasonable. Those list of considerations fit into 3 broad categories, the first being whether or not there was a valid reason. This valid reason must be related to the person's capacity or conduct. And in general, as discussed, there are four main reasons which could constitute a valid reason for unfair dismissal purposes. They are unsatisfactory performance, misconduct, incapacity, unable to do the role, or operational requirements. That's a redundancy situation. The second broad issue is in relation to procedural issues. That is, whether the person was given an opportunity to respond to any reason related to the capacity of conduct, any unreasonable refusal by the employer to allow the person to have a support person present to assist in any discussions relating to the dismissal, and if the dismissal related to unsatisfactory performance, whether the person had been warned about that unsatisfactory performance before the dismissal. And thirdly, the Commission has a broad discretion to consider any other matter which it considers to be relevant. In the past, the Commission has emphasised in consideration of this factor the importance of policies and procedures, as well as being critical of differential treatment of employees. Other common claims that we see in relation to where there's a management of performance or misconduct is general protections applications, as referred to earlier. Discrimination applications have become more common, and forced workers' compensation. And that can often be utilised, again, in circumstances where, for whatever reason, the employee is unable to bring an unfair dismissal application and they're not able to work for health reasons. Turning now to performance before I then get on to conduct. The most common reason that an employment relationship comes to an end is that an employee's performance does not match the expectations of their employer. The ease of an employer to establish a valid reason for a performance-based dismissal will depend on the nature of the employee's role. I must say it's a lot easier if you take the salesperson's example to monitor their performance and use their performance as a basis for dismissal on performance grounds. The reasons for that is that a salesperson will have a budget. And if that monthly budget, an example, is not being met, it's a fairly easy and a very objective way to move towards a performance-based dismissal on those grounds. I'm conscious that a lot of other roles, such as nurses and teachers, it's a lot more subjective in terms of the issue of performance. And for that reason, it's a lot harder to utilise performance-based processes as a basis for dismissal. In terms of performance management, a tip in terms of performance management is to have in place an appropriate structure, including documents directed towards managing issues that arise regarding employees' performance. I know that over the years that the Fair Work Ombudsman has produced some template documents, and these include performance meeting plans and performance improvement plan documents. The underperformance meeting plan, as is suggested by its title, directed towards raising the performance conduct issue or issues, and the performance improvement plan is directed towards an employee's not meeting the required standards. That document is very helpful in terms of identifying the performance that needs to be improved, establishing timeframes and possible consequences if the performance doesn't improve. I think these are very helpful documents. One observation I would make, and a tip if you like, is that when utilising these documents, it's important to consider which document you actually use for the start of any performance management process. So you don't go straight to a PIP, for instance, if it's the first time you're having a discussion with an employee about their performance. My suggestion is you look at something more like the underperformance meeting plan and counselling first, try and identify the issue and get them in terms of improving their performance to the required standard before moving to PIP. In terms of the ability to challenge the performance managing process, you can obviously do that through an unfair dismissal application. And some of the key procedural fairness concepts in the concept of performance management include an opportunity to respond to concerns about performance, an opportunity to improve that performance, and the provisions of warnings if performance is not at the required standard. And certainly those documents that are available through the Fair Work Ombudsman can step you through and ensure that you're complying with those procedural fairness requirements. In terms of warnings, tips from our experience in relation to warnings from the decisions of the Commission, preferably they're in writing, even if the warning was provided initially orally. So quite often might be the case that contemporaneously a supervisor or manager is giving an on-the-spot oral warning that's provided. Now, that should always be followed up with something in writing so that it can be relied upon down the track. Because certainly in our experience, when it becomes a disputed situation, such as before a commission, you quite often see a situation that comes across our desk where you have an employee who says, look, I've done it on this date, and in response to that, you've got a worker saying, never received a warning. Obviously, with the written documentation, if it can be signed as well by the worker, that's even more helpful. But the written proof of that is becoming more and more critical in our experience. In terms of the warning, make clear the problem with performance or conduct. There's no point giving a warning which is saying, I'm giving you a warning in relation to your performance. It's meaning the detail of what that warning is about needs to be clearly contained in the warning itself. Set out the required standard, using the salesperson's example. If the required standard is to sell 10 widgets a month, that should be set out in the warning, and the identification of the fact that that hasn't been complied with could be expected in the future. It's always important to set a time frame for reviews of warnings. Quite often you get the warning that's given, and then 12 months later another issue arises, the employer seeking to rely upon that early It's much better, in my experience, to actually set a point of review. That might be a month, it might be 6 weeks away, at which you can discuss whether or not the employee actually meeting the required standard at that point. If it can be linked to a job description, a policy, or better. In terms of the policy itself, the content of that policy should be communicated effectively and appropriately, and there should be comparable treatment in relation to non-compliance with any policy. An employer that has a policy with reasonable standards of which the employee is aware can utilise that to underpin a decision by the Commission for the valid reason for dismissal. And I'll talk about the importance of policies at the moment. In terms of final warnings, the same principles of procedural fairness apply equally to final warnings. They should have a deadline or a time frame and should set out corrective action that's required. Most importantly, the final warning should warn the employee that in the absence of improvement to the required standard, that their employment may be terminated. Now that might be something that's obvious, but certainly in my experience, final warnings don't often have that warning. I think sometimes employers get a bit nervous that might be seen to be too aggressive, but in the absence of that warning, there can be a finding by the Commission that the employee wasn't aware that they were at risk, their employment was at risk if they didn't meet the required standards. If you can, in a final warning, I think it's also sensible to reference prior warnings and issues. I think it's really helpful as you're getting towards a dismissal to be able to set out the background. The more background you can get in a warning close to the end of the dismissal or a final warning, or both, the better, because it sets out the background of the issues that you've been having as an employer, what's been done to address those issues, any meetings you might have had, and so forth. And that's a very helpful document in terms of defence of any unfair dismissal application that you face down the track. In terms of termination, the employer may not meet the required performance standards after the provision of the final warning. An employee should at this stage be provided with an opportunity to respond to their ongoing failure to meet the required performance standards before a decision is made to dismiss them from their employment. So what that means in practice is that having given a warning, if somebody's not meeting the requirements, in a week's time, you don't just walk in there and terminate the employment. You give them an opportunity to respond to the fact that they're not actually meeting the requirements. That could be in the form of a meeting, and most logically it would be. The dismissal then itself needs to be communicated in writing. That's actually a requirement of the Act. And I think it's important to remember this requirement. Certainly, in my experience, with modern technology, it's less and less the case that we actually put the dismissals in writing. But it is a requirement of the Act, and it's important that that still be complied with by employers. A strategy that we found works really well in terms of performance-based dismissal is to provide in the letter of termination for an internal right of appeal within the employer. And that's obviously a different manager to the manager who's made the decision to dismiss. So it's really only an option that's available in a larger business. But we have found that's a very good way of actually managing any issues, in particular that the employee or worker might have with their supervisor or manager who's made the decision to dismiss. And you can deal with issues internally and use that as a mechanism really to work through the dismissal and perhaps reach a commercial resolution in relation to the dismissal without the need for it to go to litigation. Because as we see, if you look at the unfair dismissal applications, 80% of those are settled at the conciliation conference. That's generally as a result of a commercial offer that's been made by the employer. So you can do that internally. There's no reason why you can't. And as I say, that's something that we've found has worked very well for our clients. In terms of conduct, misconduct might be another reason that's used as a basis for the dismissal of and in terms of procedural fairness, there are a number of issues that might arise when an employer is seeking to comply with such obligations in the context of conduct. in terms of the basis of the decision, there's a definition under the unfair dismissal laws of seriously justifiable. That is found in Regulation 1.07 Fair Work Regulations. And it provides clarification as to the circumstances that justify dismissal for misconduct. However, it does not displace the common law. So two conditions must be satisfied at common law in order to justify dismissal for misconduct. First, there must be a breach by the employee of the terms of the contract or a demonstrating intention not to be bound by those terms. And secondly, that the conduct must be sufficiently serious to allow for summary termination. In terms of the first issue as to whether there's a breach by the employee of the terms of their contract, one of the ways in which that obviously occurs in the context of a breach of policy or procedure of the employer. It may well be in a conduct situation that you need to consider whether or not to conduct an investigation into conduct, particularly in circumstances where the conduct is not admitted. And this particularly arises in matters such as sexual harassment or other sexual misconduct. In that situation, it is best practice to conduct an investigation, and from which a report of the investigation can be prepared. A sound approach is the preparation of a report by an investigator with recommendations, which is provided to a different manager who makes the final decision as to whether disciplinary action is appropriate and the form of that action. At the conclusion of the investigations, the findings made by an investigator will be relevant and often given some weight, particularly if any written report is soundly based by the Commission their dismissal application. A decision may then be made by the decision maker that disciplinary action up to termination of employment, depending on the circumstances. The reason of that dismissal should then be provided to the employee. In terms of some common issues that we find, bias is a common issue that arises, and it may be presumed if, for example, a superior, the person conducting the investigation, has already expressed adverse views about the alleged perpetrator. We often see this in the context of, say, a supervisor or manager performance managing an employee, and then a conduct issue arises. And that same manager is the manager who's making the decision to terminate. An employer in that situation needs to give appropriate consideration to this issue, in particular before it appoints an investigator to conduct an investigation or to make a decision based upon that report of the investigation. And I appreciate that in a small business that might not be possible, but certainly in a larger business where there are multiple managers, an employer should consider their options in terms of having different people doing different roles. Written complaint. Another frequent request from an employee under investigation is to request to see the actual written complaint about their conduct. Now, at common law, there's no obligation for an employer to provide the written complaint. So what you're looking at in the context of unfair dismissal laws is that the obligation is to provide sufficient particulars of the allegations raised in the complaint, and they should be provided during the course of the investigation. In many situations, it will be undesirable to provide the written complaint because it may contain irrelevant material, allegations the employer may think are trivial and inappropriate to deal with, personal information about the complainant, or even allegations against other persons. But as I say, you can refuse to decline to provide the complaint, and the obligation is to provide sufficient particulars in order to enable the employee to respond to the allegations that have been made.
Sorry, can I just ask?
Yeah.
So is it actually preferable then that the identity of the complainant is protected in that situation?
I think that that's really going to depend on a case-by-case situation. I think most employers would want to protect the complainant. What I would say though is that sometimes that's not always possible, particularly in a situation where you're dealing with allegations that are clearly made by one person against another, and that will be apparent from the nature of the allegation. So certainly allegations are made, it's going to be apparent from the person against whom they're being made as to who's complaining about them. So quite often that will be the case. But I must say that in my experience of looking at complaints, they do quite often fall into the category of having information about others, information that's relevant to the complaint, and not really structured in a way that the employer necessarily wants to put the allegations. So there's not a great deal of value from the employer's perspective in providing a complaint in that context. It's much better to set out the allegations in an appropriate way. So when we're talking about allegations, the nature of the allegations and how they're put is really important. It's something I find that employers struggle with. Correspondence provided to participants, particularly alleged perpetrator during investigation about an employee's conduct, is important, and they're going to be documents that you're going to rely upon in any claim that's brought against the employer. An employer should carefully draft allegations of misconduct, as they can sometimes lead to a presumption or inference that the employer has already made a decision about misconduct. And you see that on television where we're seeing on the news something about a court matter and said it's alleged that. And it's important that that language also be used in the context of lettered allegations, because if you frame it in the sense that you did this or you did that, it's assumed, is it not, that the person is already, in your eyes at least, guilty of misconduct. So it's important that any allegation, any lettered allegations, contains allegations that is expressed in that way. So don't say it's alleged that ABC occurred. Any lettered allegation needs to ask questions about a particular circumstance and ask for the explanation as to why ABC occurred. An employee will often seek further details of allegations after they're put to them by an investigator. This, in our experience, can be used as a delaying tactic, but the allegation should contain sufficient detail to enable the alleged perpetrator to understand its nature. In addition, an allegation should identify the rule or policy which the accused is alleged to have breached. This means, for example, where an employee's conduct is said to have breached a policy, a term of the contract or enterprise agreement, then that policy's provision or protocol ought to be clearly indicated. So one of the instances we see on a regular basis is someone being late for work, and not communicating that to their supervisor in accordance with the policy. So what needs to be put there is not simply that you're late for work, but it needs to be put on the basis that you were late to believe you were late to work on this date, at this time, and you arrived for work at this time, etc. And then the policy needs to be put. So it needs to be put on the basis that there's a policy whereby if you are not on time, then you need to contact your supervisor as soon as practicable. And that's in accordance with Clause 11 of our policy. And what we're investigating is whether or not you complied with this policy on this particular occasion. So that's the way in which the allegations need to be put. It may well be that things take place during the course of an investigation into misconduct. There might be records of meetings taken. You don't need to take records of meetings, but certainly best practice to take a notice of meeting. In terms of provision of those meetings to participants, so somebody who had allegations made against them, there's not a requirement to provide them, but I must say I've found that it works really well, and it's a good practice in my experience to do it. We see more often in our unfair dismissal applications and other applications that we see diametrically opposed versions of events as to what happens at disciplinary meetings these these days. And there is a bit of an approach from workers who are bringing unfair dismissal applications to simply deny everything. It's deny, deny, deny. It's the Donald Trump approach. And that seemed to be the way to deal with allegations such as those put at meetings. So your ability to actually record the meeting itself and actually provide becomes really important, because what's said at these meetings, you know, whether allegations were put, what the response was to the allegations. And in a lot of occasions, what we're seeing is that people aren't necessarily denying conduct at meetings, but in their unfair dismissal application, they say, I didn't do A, B, C, or D. But hang on a minute, you didn't deny it at the meeting. And if you've actually done the meeting notes and you've provided them to as part of the meeting process, that then becomes a critical piece of evidence in terms of the defence of any unfair dismissal application, and quite helpful in terms of getting the Commission over the line in terms of position. Some of the other matters that are significant, the time to respond, how much time you're giving to respond to allegations, and you need to give a reasonable time. The Commission is pretty laxed about these timeframes. If you're sort of trying to get a response within 24 hours, it's probably not going to satisfy the Commission. The Commission is going to want to provide somebody with, say, at least 48 hours to respond to allegations if they are serious. And if they are serious, it's appropriate to consider suspension during that period as well. That would normally be on a paid basis. One of the other factors that we see is quite often that people will become ill when allegations are put to them. In my experience, that obviously causes some difficulty in terms of the process, and it might be that the process changes. So instead of having a meeting about the allegations, it might be that you're looking at a letter of allegations. And the reason why you don't have a meeting, as is explained, is that the person is sick. You proceed on that basis. I don't think it needs to stop the process, but you need to consider the basis of the illness to make a decision about that. Other issues that might arise is the issue of legal representation during an investigation or disciplinary process. In terms of that issue, there's no obligation to provide legal representation. I think where it's important to really consider it from an employer's perspective is when there's an accusation of unlawful conduct. So where the accusation is something, for instance, like theft, it's appropriate, in my view, for the employer to consider whether or not they should provide to the employee an opportunity to obtain legal advice and legal representation during the course of the process. It may well be that their advice is not to respond to any questions, so not to respond to any letter of allegations. Now, the fact that an employee does that doesn't mean that you can't continue ahead with your investigation. What that means is you don't have a response, and you can base your decision in terms of disciplinary action, including termination, upon the information that you had in your possession. So it doesn't stop the investigation. From employment perspective, all it means is that you don't have any information from the alleged perpetrator in relation to the conduct. Other matters that might arise, again, we see from occasions a request to properly examine witnesses. It might not just be the complainant, but other witnesses. And again, there's no right that exists for an employee to properly examine or directly challenge the evidence of the employees who have made a complaint or other witnesses in support of that complaint. As I said earlier, the employee should have an opportunity to respond to the allegations that have been put during the investigation, which is often afforded at an interview by the investigator. Generally, it's appropriate to invite an employee to be represented at the interview conducted during the investigation where the potential exists that their employment could be terminated by the court. So again, it's appropriate to consider representation of a support person when you think it's heading towards termination. An employer should also act in accordance with specific requirements of any policy or procedure for contract of employment in terms of the process that they utilise. Sometimes employers will have policies grievance and disciplinary policies, and make sure at the start of the process you're having a look at what those requirements are to make sure you're complying with them. The other factor of significance in our experience is the issue of delay. You can't delay investigation of a serious matter. The reason for that is that if you do, you could be seen to be condoning conduct. So if, for instance, something happens, you as the employer is aware of it, it might be, say, an instance of sexual harassment, and then you do nothing about it for 6 months. If you were to then investigate it at that 6-month point, you are going to face a challenge to the reason why you've delayed, and what you're going to face is an argument that you condone the conduct as the employer. It doesn't make the conduct right. What it does do, though, means that you're not likely to be able to use it as a basis for dismissal. In terms of recent decisions and recent developments, in this context of conduct, as I said, one of the ways in which an employer will often seek to demonstrate a breach of contract is through contravention of a workplace policy. And I thought it was helpful to discuss a couple of recent case examples, one which falls on one side of the line, one which falls on the other side of the line in terms of the success by the employer. So the first case involves a case of pornography in the workplace, and it was a workplace operated by an insurance broking business. Now, generally speaking, accessing or using pornography at work or using a work computer will amount to a valid reason for termination of employment in an unfair dismissal context. A recent commission decision of Sparta Insurance Broker, though, serves as a warning for all employers about the importance of having a policy in place that prohibits pornography. Facts of this case were that the worker's problematic conduct, including downloading and storing hardcore pornography, including images and a video of themselves performing sex acts on work equipment. And this conduct would seem on the face of it to be well and truly serious enough to warrant dismissal. However, the Commission found that the dismissal was unfair. The Commissioner in this instance found that although downloading hardcore pornography onto work equipment, either during or after work hours, would ordinarily amount to misconduct, warranting the discipline or dismissal worker, they found that in this case, it did not represent a valid reason for dismissal, so they didn't even satisfy it was a valid reason for the following reasons. The employer had not communicated any policy about the use of its equipment being confined to work-related activities. Now, I just want to pause there for a moment and think about that. So it's really the case that you have to have a policy in place to tell people not to do this. It's like telling people you must wear a seatbelt when you're driving a work vehicle. But anyway, I digress. The second reason was there was some contested evidence that the directors may have also participated in acts. And that's really a problem. That's really a problem. And the employee had only downloaded pornography on 3 occasions. I'm not quite sure what the Commission was thinking back to that conclusion. But anyway, a clear takeaway from this case is the need to have in place a policy about what is acceptable use of work equipment that everyone, including the directors, complies with in the workplace. Now, this is a really good example because it seems to me it's obvious that what the person is doing is wrong. Yet, despite that, the Commission has held in the absence of a policy, critical reasons, the absence of a policy meant that the employer couldn't rely on that reason for the purpose of dismissal in an unfair dismissal context. But the second decision, which is again a recent decision, involves one of Australia's largest insurers, IAG, and it's one where the Commission found on the other side of the line. In this case, the worker had been employed by IAG since 2005. Like many employers, IAG had moved towards a hybrid approach to working from home. So they were permitting working from home, and that, much like many other employers in the industry, had expanded through COVID. In 2022, though, IAG changed approach following the end of COVID, or perhaps not the end of COVID, but at the end of the approach that was being taken in terms of lockdowns and the like. And the company had begun requesting employees attend office more regularly from that time. The worker in this case had chosen to remain almost permanently working from home. And in the period between October and December 2022, IAG conducted a review of the worker's cyber activity and laptop use while she was working from home. There was a report that was prepared, and that got to the level of detail of measuring keystroke activity and showed significant periods of little to no activity during this period between October and December. In particular, there was 0 keyboard strokes for over 117 hours in October, 143 hours in November, and 60 hours in December. The report also disclosed that the worker failed to work her designated rostered 44 days out of 49 days reviewed, failed to start at 7:30 a.m. as required on 47 days out of 49. The worker failed to finish work at or after 4 p.m. as required on 29 days out of 49. Didn't perform any work on 4 days and had low keystroke activity on the day she was logged in, which demonstrated she was not working as required. IAG conducted an investigation where I put a letter of allegation to the worker, and she was given a opportunity to respond to that. Following that, on the 20th of February this year, IAG dismissed the worker for misconduct, alleging that she had failed to work as required between October and December. The worker maintained that she couldn't understand how or why the data showed such low working periods and raised doubts as to the report's accuracy, and she brought an unfair dismissal application. The Fair Work Commission's findings are interesting. Firstly, was there a valid reason? And the Commission accepted the report on cyber activity as evidence establishing significant periods where the worker was not working as required. Crucially, the worker was unable to provide a credible explanation regarding her non-performance or evidence to demonstrate her work for that period. The worker's failure to work as required for extended periods constituted a valid reason. Given the work was dismissed for misconduct or failing to attend work rather than poor performance, the issue of a warning wasn't a relevant consideration. So the worker had raised in this case, I haven't been warned about this previously, but because it was dismissed for misconduct, the Commission held that it wasn't necessary to give her warnings in relation to what had taken place. The Commission didn't otherwise find that the worker's dismissal was harsh, unjust, or unreasonable. On that basis, the worker's application was dismissed. Perhaps in a surprising twist, she actually appealed that decision and was lost quite spectacularly on appeal. The key takeaways, though, from this decision, it's quite a novel case, and it considers the modern issue of monitoring remote work. Firstly, it confirms that where employers can prove that a worker is not working diligently or attending their duties, they will be able to justify a dismissal for misconduct. Secondly, and as importantly, it demonstrates the importance once again of having in place appropriate workplace policies, which in this case enable the employer to monitor an employee's activity and then rely upon that monitoring to justify a reason for dismissal. So clearly you can see from those two cases the importance of having policies. In the first instance, an employer that didn't have a policy in place will not get the difficulty that caused in relation to the dismissal decision. And secondly, where you did have a policy, in this case IAG's policies, which enabled it to monitor work performance in the way in which it did, which spectacularly justified a reason for dismissal in circumstances where some workers might not see that as justifiable. I appreciate it's a cultural issue about whether the employer may wish to engage in that sort of activity, but it does demonstrate that you can with an appropriate policy. I just wanted to finish on a further recent decision of Quantas, which is relevant to this area. So some of you may well have seen some publicity in relation to the recent Quantas decision. I think it was a matter of sort of everyone piling on Alan Joyce at once. But there was a High Court decision that was handed down in weeks that's relevant in relation to managing performance and conduct of new employees to your business. Quantas appealed to the High Court related to a general protections application in which the TWU successfully argued that the airline's decision to outsource the jobs of over 1,600 ground crew was unlawful. The High Court agreed on appeal that Qantas had made the adverse decision to outsource was motivated in part, at least, to prevent this group of employees from bargaining, which could have included taking industrial action in support of a new enterprise agreement. And we all know what history Qantas has had in relation to its bargaining, and that quite often that's been done aggressively by both parties, including Qantas, of course, closing down its operations several years ago. The interesting aspect of this decision is that the workforce's ability to bargain and take industrial action was not an existing workplace right at the time. At the time of Qantas's decision to outsource, the TWU and the workforce were not able to lawfully take industrial action against the airline. The High Court agreed, though, with the Federal Court that Qantas had made its decision to outsource, which eventually led to a restructure and the termination of a group of its workforce, to prevent bargaining and industrial action, which prevented the workforce from exercising a workplace right that they would have in the future. It's not a current workplace right, it's a right that they would have in the future. On this basis, the High Court rejected Qantas's appeal, finding that the airline had contravened the general protection provisions of the Act on that basis. So what's the effect then of this decision in relation to the area that we're looking at today? The effect of the decision is wide-ranging, with the potential for it to inspire claims against employers who seek to prevent the exercise of future workplace rights. A possible example of this is the common dismissal of probationary employees for performance, conduct or other reasons shortly before the end of a 6-month probationary period. The employer's dismissal of the probationary employee means that they have not satisfied the minimum employment period to enliven the unfair dismissal jurisdiction. With the benefit of the Qantas High Court decision, a probationary employee could argue in a general protections application that the decision to dismiss them shortly before the conclusion of their probationary period prevented them from exercising their future workplace right to lodge an unfair dismissal application. Employers may, on this basis, wish to review their probationary requirements to consider whether they might want to change these, in particular to reduce the probationary period from 6 months, which obviously coincides with the minimum employment period, to a shorter period, and that might be 3, 4 or 5 months, such that there's not such a connection between the length of the probationary period and the minimum employment period, because if you're using the same period of time, it's not hard for an employee to argue that the reason why you're terminating them right at the very end of the 6 months is to avoid them from being able to exercise that future right to bring an unfair dismissal application. Hence, their general protections application is successful, for which they're able to receive damages that are not limited as they are for an unfair dismissal application. So in practice, all employers should, in my view, based on that decision which was recently handed down, reconsider the way in which they manage their probationary employees, including the length of time that they use as a probationary period for the employees to manage this particular risk. On that note, I'll finish my talk for this morning. Thank you all for coming in this morning, and I'm happy to take any questions that anyone has at this particular moment.
So,
Yes.
so just with that preference for 3 months as a probationary period, obviously in that time, the employer will need to be far more purposeful and driven about uncovering performance standards and capabilities in that 3 months. Often over 6 months, you sort of maybe would have a review once a month, but if it's 3 months, maybe the reviews would need to be tighter and more often.
Sure. No, I mean, I agree with that approach. And I guess the point is whether it's 3, 4 or 5 months, what you're not doing is you're not linking that to the employment period. So it seems to me you do manage that risk, but you're right. It seems to me that you might need to review how often you meet, and it might just be that you're having the same meetings in a tighter time frame, and that's 3, 4, 5 months, depending on the level of risk that the employer is prepared to take in relation to that issue.
Thank you.
The recruitment process
Yes.
and tips and tricks on what to do during the recruitment process to potentially deal with or minimise these sorts of cases.
Sure. Well, look, I do appreciate with the current skill shortage that it is a challenge out there for all employers, and you're probably employing some people who wouldn't otherwise in regards to compliance. But certainly in terms of my experience is that reference checks, CV checks, and those sort of things are very helpful in terms of working out who the employee is. Word of mouth is often a good way to find good candidates. What we find at our firm in particular is that we generally know who's out there and who the good people are, but it certainly helps with word of mouth. People who work with people in the past that you can speak to, talk to about their performance, because it's often difficult to talk, obviously, with their current employer because they don't want to disclose that they're considering other options. Yeah.
Is it actually okay, so someone applies for a job, you know they work for someone that you know previously,
Yes.
and you actually contact them directly? I had a feeling there was some sort of ruling that you couldn't approach or get reference checks from.
Sure. Well, you can, of course, do any of those reference checks with the permission of the employee, and certainly with the onboarding process that we see now, that's generally a requirement that you put forward names of people who can be contacted, or there's an indication that the employer will be contacting people and conducting their own reference checks. And certainly through that, if that's agreed to by a candidate, then
So outside of the list that they.
yeah, outside of the list, correct. So certainly if you're communicating that and the candidate agrees to that, that doesn't prevent you from contacting others outside of the list.
And thanks very much.
Sure,
I'm grateful, Chris from Faircare Group. Just taking you back to support person,
Yeah.
very small point, but I've typically always given a support person all the way along from a first warning, second warning, obviously in that sort of final meeting. But I think I heard you say a support person isn't necessarily required at a potential first written warning. It's more so towards the end.
I agree with that. I mean, I think if you've given the option of support person all the way through, that's fine. That might be seen as best practice, but I wouldn't necessarily see it as a requirement. So,
okay, thank you.
So at a first warning, for instance, I wouldn't see it necessarily requiring access to a support person
Okay.
in that situation.
Yeah, great, thank you.
Because you're not importantly what you're not doing is dismissal.
Yes, okay, thank you.
And your observation is right, that is towards the end of the process, that's where you certainly need to consider it.
Yeah, absolutely. Okay, thank you very much.
Just going back to misconduct or performance meetings, where you said record meetings, do you mean in that fashion somebody scribing down what is said, or would you put a
It
recorder?
doesn't necessarily have to be in that format. There'd be nothing wrong with having two people in the meeting, one from management and an employee who's the alleged perpetrator or the like, and then you can go away as the manager and take down notes after. No problem with that. process, because what it is a contemporary record of what's taken place if you're doing
Sorry.
that. So I'm not sure. Go on.
So in respect to misconduct, if you have a complainant come to you, so one of your employees come to you, visibly upset about a situation, explains what has happened, then puts it in writing in an email, but then turns around and says, oh, I don't want to make a big deal about it. I don't want to formalise anything. How would one approach that type of situation? Like, is it
That's probably another 1 hour session.
yes, that's a one-on-one meeting,
uh,
right?
You're describing.
Can the line manager or the employer speak to, you know, the person that's being accused of said misconduct, and address that despite the complainant not wanting to formalise it?
I think it's very much like the Brittany Higgins situation, and I think the approach to that's probably changed since that particular situation from an employer's perspective, because most employers now are pretty nervous about taking no action in that situation.
Yeah, you don't want to just let it go.
What then happens is that you've obviously got knowledge about certain allegations, and if you do take no action as an employer, it seems to me you're placing yourself at risk. So most employers will act, and it's the same advice that would be given in relation to whether or not somebody makes a complaint or not. An employer might be aware of conduct that has occurred, but there might not be a complaint. That doesn't mean that the employer can't act upon that, investigate that conduct. And certainly that's what we're seeing from our employers, that there's more of an inclination to act rather than not act these days, and that's not surprising.
You're not then breaching the privacy or?
No, I don't see that you are. I mean, there's a balancing of risks in that situation. Obviously, in that situation, you might have somebody who's not making a formal complaint, so they're not necessarily formally complaining about the conduct. But I think in that balancing of risk, most employers are making a decision to go and investigate, particularly if the allegations are serious. Okay. One final question at the back.
Just in relation to warning letters, and obviously we get the situation where you deny later, where the employee refuses to acknowledge that they've been given a warning
Sure.
letter.
Sure.
Any tips on?
I think that's standard union advice. Don't sign it.
Yeah.
So that's certainly a common in factory environments. In that situation, if you can, what I would do is send an email with a read receipt, and that's the way of making it clear that the person's received it. I might not sign back to you as part of that process, but at least you've received the. Okay. Thank you again for coming in. Feel free to stay and have a chat with your colleagues, and I think we've still got some food and drinks for your area.
Thank you.
Thanks.